If it is found by the committee that a false allegation or a malicious complaint is made just to put the respondent in trouble, it may recommend the employer or the district officer, as the case may be, to take action directly against the aggrieved woman or the complainant as per the service rules. It shall not be tolerated by the committee or the justice system that such frivolous, malicious or complaints are made with false evidence. It shall amount to perjury if false evidence is given, and the aggrieved woman may not only be liable under the service rules, but also may be proceeded against under the Indian Penal Code and any other legislations that may be applicable in that case. In absence of any service rules, Rule 10 shall apply, and the employer shall proceed under Rule 9 of the service rules. Inability to substantiate a complaint or absence of proof or inadequate proof shall not attract action against the complainant under this section. It is necessary that it is proved through substantial evidence that the complaint made by the complainant was false or malicious, or that the complainant has given false evidence. The prosecution in this case has to prove it beyond reasonable doubt. In case of giving false evidence, non-production of any forged or misleading document, it may be recommended that the employer of the witness or the district officer may take action as per the rules provided under Rule 10 of the SHWW Rules 2013. Now, as provided earlier, if the aggrieved woman is awarded compensation either from the salary, wages or remuneration of the respondent or from the land revenue in absence of such employment, the determination of compensation shall be done under section 15. And for the purpose of determining the sum that is to be paid to the aggrieved woman, the internal committee or local committee shall have regard to the mental trauma, pain, suffering and emotional distress which is caused to the aggrieved woman because of the circumstances and because of the sexual harassment that was caused upon her by the respondent. Secondly, the loss in the career opportunity due to the incident of sexual harassment, any effect which has happened on her with regard to her work performance, with regard to her present employment or with regard to any future employment which may be affected by such act of sexual harassment. Thirdly, any medical expenses in case of any physical or emotional or mental abuse which has happened to the aggrieved woman from such sexual harassment. In such case, if any medical expenses are incurred by the victim or the aggrieved woman in this case for physical and psychiatric treatment, those expenses shall be taken into consideration and added to the amount of compensation that is to be paid to the aggrieved woman by the respondent. Fourthly, the income and financial status of the respondent has to be seen, and how much injury is caused, how much financial loss is caused by such act of sexual harassment is also to be calculated and kept in mind before making a decision with regard to calculation of the compensation of the for the act of sexual harassment for the aggrieved woman. Lastly, feasibility of such payment in lump sum or in installments is to be kept in mind. In this case, it is not dependent on the aggrieved woman much rather, but it is more dependent on the person who is paying, that is the respondent, whether he is able to pay a lump sum amount or not and whether he can pay it in installments. Whichever is feasible in the case will be applicable, and the committee, the respective committee, internal or local, shall award such compensation in such manner. It will also depend on the aggrieved woman if she needs a lump sum amount or she can do with the payment in installments. Another act which is prohibited under the Sexual Harassment of Women at Workplace Act 2013 is the publication of any contents of complaint or any inquiry proceedings. If any publication is made irrespective of the contents of the Right to Information Act of 2005, if any publication is made of the contents of the complaint that is made under section 9 in writing with regard to the identity, the addresses of the aggrieved woman, of the respondent, of any witnesses or any information regarding the conciliation or inquiry proceedings, any recommendations of the inquiry committee or local committee as the case may be, and any action taken by employer. If it is published, then it amounts to a criminal offence and penalty shall be taken for it. It is prohibited under this act under section 16, and it shall not be published under any circumstance, communicated or made known to the public, press or media in any manner, provided that any information may be disseminated. This acts as an exception to the said prohibition given under section 16. If the information is regarding the justice secured to any victim of sexual harassment under this act, without disclosing the name, address, identity or any particulars which may lead to identification of the aggrieved women or witnesses, if any publication is made, then that may not amount to a violation of section 16 of the act. If such publication is made and in contravention of section 16 of the act, then the person who makes such publication shall be liable for penalty in accordance with the provisions of the service rules if applicable, and where such service rules do not exist, that is in case of a domestic worker or in any other case, rule 12 shall be applicable, and the employer shall recover a sum of rupees 500 as penalty from such person who makes such publication and makes known the identity of the victim, respondent, aggrieved woman or the witnesses to the public or media. If any person is aggrieved by the order given by order or the report made by the inquiry committee, the internal complaints committee or the local complaints committee, then that person can move in appeal. Any appeal can be taken on the following orders. First is the committee's recommendations to the employer. Second is recommendation to the employer with regard to taking action against the respondent on the allegation that sexual harassment has been proved. Thirdly, recommendation by the committee to deduct sum determined, that is payment of compensation. Fourthly, recommendation by the committee to take action against the complaint as per service rules on the ground that the complaint is malicious. Fifthly, recommendation of the committee to take action against the witness for giving false evidence or producing any forged or misleading document. Sixthly, non-implementation on any of the orders by the employer, that is the recommendation, if the recommendations are not followed by the employers in that case. Seventhly, if the person is aggrieved by any penalty which is imposed on an employee dealing with the complaint or any other information as per service rules which is pending the parting the information according with section 16. If the act is not complied with in toto or any part of the act, this act refers to here the Sexual Harassment of Women at Workplace Prohibition, Prevention and Redressal Act of 2013, any provision of the act that we have seen so far, if it is not followed or if it is violated and the employer here falls to constitute an internal committee, take action against the wrongdoer or malicious complainant even after the internal committee or the local committee has given a recommendation or contravenes any other provision of this act or any service rules or the rules of the SHWW Act, he shall be punished with fine which may extend to a sum of 50,000 rupees. That is the penal provision which is given under this act with regard to non-compliance with this act for an employer. In the second subsection, it says that if any employer, after having been previously convicted of an offence, if he is subsequently convicted of the same offence, that is if he is not following any recommendation for a second time, or if he has been if he has not addressed a complaint in the first time of sexual harassment and again he at the second time also neglects such complaint or does not take action against the wrongdoer for the second time, he shall be liable for twice the punishment, that is the sum may extend to a sum of 1 lakh rupees. Secondly, cancellation of his license or withdrawal or non-renewal or approval or cancellation of the registration as the case may be made by the government or local authority as the case may be required for carrying on his business or activity. So, that is the other penalty which is applicable in case of non-compliance, along with the submission, along with the payment of fine of rupees 50,000 or 1 lakh as the case may be, depending on whether he is a first time offender or a repeated offender. Alongside that, in addition to that, a cancellation of his license or suspension of his license or cancellation of his registration for carrying out any business or activity of that individual may happen in according to the provisions of this Act under section 26. Now, to ensure that sexual harassment is curbed at each workplace and also to impose certain responsibilities of the employer to keep a work environment free of sexual harassment or any kind of harassment against women who are treated as a vulnerable population in case where harassment is concerned in the workplace, certain safeguards are provided under section 19 of the Sexual Harassment of Women at Workplace Act 2013. These safeguards are provided in the manner of duties of the employer, and they read as follows. The employer is supposed and shall provide a safe working environment at the workplace, including the safety from the persons coming in contact at the workplace. That is, it does not only apply to the employees who are working under the employer, but also extends to persons who are visiting the workplace, a student, an intern, or any other person who may or may not come in, may come into contact with the employee or the employer in the due course of employment. Secondly, the employer shall display at a conspicuous place the penal consequences of harassment and internal committees. Therefore, it is required for the employer that he puts up a notice board or at a conspicuous place which can be seen by all the employees and other employers and co-workers, that if any sexual harassment or if any act of sexual harassment is committed against an aggrieved, against another party or against an employee or co-employee, then there must be penal consequences according to the SHWW Act or any other rules which may apply. The employer shall also organize any workshops or awareness programs at regular intervals for sensitizing its employees and create awareness amongst them to show that sexual harassment will not be tolerated in the work premises, and to generally make them aware of, make the aggrieved woman aware of the fact that if any sexual harassment takes place in the workplace, they do have redressal mechanisms which they can adhere to or which they can rely upon at the time of such incident. The employer shall provide all the necessary facilities to the internal committee who is dealing with the complaint. Therefore, the chairperson or the members of the committee are to be served properly by the employer, and the employer shall make sure that they are functioning properly, and anything which is necessary for the functioning, for the proper functioning of the inquiry committee, for the proper functioning of the internal committee dealing with the complaint, if there is a complaint by the aggrieved woman, that shall be taken care of by the employer himself. The employer shall personally assist in securing the attendance of the respondent and witness before the committee, so as to make the work of the committee easier and smooth flowing, and make the inquiry process more smoother, so that the aggrieved woman is secured justice at the end of the inquiry. The assistance to the woman also is to be provided by the employer if she chooses to file a complaint before the internal committee. Also, if she chooses to file a complaint, a criminal complaint aggrieved by the act of the harasser under the Indian Penal Code or any other criminal legislation, then the employer is supposed to assist the employee or the aggrieved woman, as the case may be, in filing such complaint before a local committee or before a police officer. The employer shall assist to the aggrieved woman in initiating any action under IPC, in filing an FIR or in filing a complaint before the local magistrate if the perpetrator is not an employee and if the aggrieved woman so desires for incident of sexual harassment of workplace. The employer shall also treat sexual harassment as a misconduct under all circumstances and under the service rules, and initiate action for such misconduct as and when an aggrieved complains of such misconduct before the employer or before the committee. The employer, it is the responsibility of the employer to monitor the timely submission of report by the internal committee. It is also the responsibility of the employer to follow any recommendation which are suggested by the inquiry committee, whether it be internal complaints committee or the local complaints committee. Similarly, similar to those of the duties of the employer in an organizational setting, in a local setting or a municipality setting, there are duties of the district officer. Wherever a local complaints committee is set up, in that case, the district officer shall monitor timely submission of reports furnished by such local complaints committee. It is also the duty of the district officer to take any measures which is necessary for engaging non-governmental organizations, that is NGOs or associations which are involved, for creation of awareness on sexual harassment and the rights of the women who are facing such sexual harassment or who are engaged in a workplace in order to provide their service. With that, we complete the provisions of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 and the redressal mechanism provided therein. It is suggested that all workplaces adopt the provisions into their day-to-day business and create awareness amongst their employees and employers in order to curb down the menace of sexual harassment at workplace, especially for vulnerable population like women. Thank you.